In our society, there is a certain expectation of a right to privacy. When we speak of a right to privacy, that is a person's right to be left alone without one's name, image, or daily activities becoming public property or becoming widely covered in news media. However, in this area, the news media has a pretty broad latitude to cover individuals that it thinks are relevant to particular stories. And the First Amendment grants news media a pretty broad latitude to cover individuals however it wants. So as part of the process of reporting and journalistic activity, reporters may publish certain information about private individuals if those news organizations believe that that information about those people is an important part of the story. So now, even though the U.S. government and court system provides news organizations a broad degree of freedom to cover individuals and violate their privacy, the news organizations themselves have internal guidelines to try and minimize this invasiveness so that the news organizations try wherever possible to respect people's privacy and to only invade that privacy if it is an important part of reporting. Now, that said, it is also important that news organizations obey the law. And we've seen in recent years some pretty high-profile instances where news organizations have violated the right to privacy for individuals by breaking the law. And one really spectacular example of that was when Rupert Murdoch's publication, News of the World, engaged in some really illegal practices where its reporters illegally hacked into the private voicemail messages of certain individuals and then used that information from those recordings as part of its story. So obviously, news organizations are expected to obey the law and not violate individuals' privacy rights that are protected by law. There have been situations where our society's commitment to free expression and a free press comes into conflict with other social principles that we value as a society. And one of these conflicts involves a conflict between the First Amendment, which guarantees free speech and a free press, a conflict between that amendment and the Sixth Amendment, which guarantees a person accused of a crime a speedy and public trial adjudicated by an impartial jury. And there have been instances where these two principles come into conflict with one another. The classic example is when a person is accused of a crime, charged with a crime, and a journalist and a news organization reports on that crime, that allegation. There has often been the worry that when the news media reports on some high-profile crime that's allegedly committed by someone, that reporting in the news media may act to bias the local community and a particular pool of jurors, right? So that people's knowledge and understanding of a particular case might be tainted by the reporting on that story by the news media, right? So in certain instances, judges have been concerned about a lot of pretrial publicity for a particular case that might bias a particular jury or possible future jury that may be drawn from that local community. So, as a result of these concerns, from time to time, judges in court cases have issued what are called gag orders. These gag orders prohibit attorneys and people involved in a court case, witnesses, from discussing that case outside of court. Again, this is intended to prevent any reporting outside of the court from biasing the news about that case, or biasing people's views about the matter more generally. Now, another area of tension between the press and the judicial system has to do when reporters and journalists occasionally use anonymous sources for information for their reporting. Right? Frequently, reporters will get very confidential inside information about wrongdoing by businesses or government from anonymous sources that disclose a lot of sensitive information that they would not be willing to share publicly. Well, from time to time, the information that a journalist reports from these anonymous sources becomes relevant in court cases where an attorney or a lawyer in a court case may want to know the source of information reported by a journalist, all right, that is relevant to his or her client, right? And from time to time, judges have required journalists to reveal their sources for information that they've reported, and if the journalist refused, then the judge might cite the reporter as for contempt of court and send him to jail. Well, news organizations strongly object to this kind of coercion and argue that that they should be able to retain the confidentiality of their anonymous sources. And journalists argue that the public interest is served by the use of anonymous sources because we as the public then gain access to really important information that we otherwise would not have access to if a person were revealed, because people would be less likely to spill the beans about sensitive matters, that they are more likely willing to do that anonymously. Now, because of these concerns, many states have passed what are called shield laws, right? A shield law protects reporters from having to reveal these confidential, anonymous sources, right? And that they protect the journalist and allow the journalist to keep that source private. And most states have some form of shield law, although there is no federal law. Another area of tension between the First Amendment protection for a free press and the Sixth Amendment guarantee of a fair and speedy trial has to do with how journalists and news organizations report on court proceedings. And in particular, there has been an ongoing controversy over whether or not cameras should be permitted in the courtroom to record the proceedings of court cases. In earlier decades, courts were very reluctant to allow cameras and recorders in the courthouse because of the fear that those cameras would distort the court proceedings, that some worried that having cameras in the courtroom had the potential to turn somber court proceedings into a carnival, and that increasingly people would play to the camera, that if people were aware of the cameras being in a courtroom, they might act in a more flamboyant, dramatic way. And that there was the worry that this might make it more difficult for people to get a fair trial. Now, over time, the U.S. Court system has become more comfortable with allowing cameras in courtrooms, in courthouses, and judges have increasingly argued that having a camera in a courtroom doesn't really make a fair trial impossible. So today, all U.S. states allow cameras in their courts to record their proceedings with some restrictions. The U.S. federal courts allow cameras under certain conditions, although the U.S. Supreme Court still continues a ban on the practice and does not allow its proceedings to be recorded by video cameras.